So this defence is called intoxication. So this handout covers both intoxication via drink or drugs, or sometimes a combination of the two. So intoxication then, this can occur through the effects of drugs, alcohol, or any substance, or a combination of all of those factors. Whether or not intoxication will ever provide a defence depends upon the type of intoxication and also the type of the offence committed. So just in other words, there are different rules for different types of drugs, for example, and also there are different rules depending on which crime you have committed. So for example, for very serious crime, there are a different set of rules for more minor crime. Intoxication is only allowed in a very limited number of circumstances. In other words, it has a very low success rate, where it means that due to the intoxication, that the defendant lacked the mens rea for the offence charged. So the structure of the defence, and therefore the structure of the handout, is as follows. First of all, intoxication. Key issue with intoxication, as we've seen with some other topics, is the distinction between legal policy and public policy. So we know that we're always looking for ideally a balance, but that's the key question that's come up many times as an essay question, for example. Secondly, the difference between basic and specific crime, and a bit of a history to that, how we got to the law today. Then the first major set of rules are the voluntary intoxication rules, which are also known as the Majewski rules. And then there are a set of other categories, which I've labelled general principles, which include intoxicated intent and Dutch courage. Then the next set of rules are involuntary intoxication. So that's where it's beyond D's control, so drugs from a doctor, soporific drugs and spiking cases. Then there is a section on how intoxication links to other general defences. For example, intoxication and automatism, so there's again another set of rules there. And then the other defences that we've just mentioned above, insanity, automatism, mistake and DR. And then finally a tiny little section on the burden of proof and the need for evidence. Okay, so what are the main problems associated with intoxication? Various things just to fill in there. First of all, there's been a conflict, an issue between the balance of legal policy and public policy. So some cases are to legal policy aimed, whereas some are too much in the favour of public policy. And really, like I said before, we're looking for a balance, and the balance the courts have failed to achieve. The second issue that has occurred with intoxication is the difference between basic and specific crime. So we've got two sets of rules for both different types of offence, basic and specific, but there are lots of different tests which suggest crimes can be either basic or specific. So in other words, as we've seen before many times, loads of different tests, and they're all different in determining what is basic and what is specific. Another problem is the categories of intoxication have changed, so the courts have added to those, so that's made the defence uncertain. Intoxicated mistakes has been historically quite problematic, leading to the current law today, which is deemed very unfair. And finally, which probably is the main issue, is that Parliament have never looked at intoxication ever, and that's probably why there are so many issues with the defence. Okay, so a bit more intro stuff. Intoxication actually strictly is not a defence, but a way of showing that D lacked the mens rea for the crime committed, because it is argued that D's consumption of the intoxicant has affected his ability to intend or foresee the consequences of his action. So it's an excuse rather than a general defence. Where intoxication succeeds, it tends to act as a partial rather than a full acquittal. So where it does succeed, it tends to drop the offence down from, let's say, section 18 to section 20 GBH. Okay, so we touched on there this issue between legal policy and public policy. So intoxication, as we just said above, has been developed by the courts and is governed by the case law only. So it's a controversial area of law, and many have questioned whether it should even exist, whether it should excuse a defendant or allow him to escape liability. It could be argued that D, who becomes intoxicated and commits a crime, is actually more culpable and probably the reason why he committed the crime in the first place. So rather than saying it's an excuse, it's probably a factor in why that defendant committed the crime. So it adds culpability rather than removes culpability. So the courts have found it really difficult to develop it accurately and fairly. And what they've tried to do is balance the two factors of LP and PP, but they've really struggled in getting an adequate balance. So, question, why is it important to achieve a good balance? Well, a couple of things to note there. It's important to protect the public. We know that because we talk about public policy all the time. It is important to protect the public, but then also D must have some human rights, which is legal policy. So it is important to get a balance between the two. Generally speaking, too much PP or too much LP tends to be not as good as a balance between the two. And also, the second reason why it is important to achieve a good balance is that the vast majority of crimes involve intoxication. So because it's most cases that come before the court, it's very important to get a good balance achieved. So, moving on to the next section. So these were just something that I used when this was special study. So you just need to know this in general terms, not word for word. But just giving you an idea there, and this will suit any legal policy, public policy essay, of which it could be self-defence, it could be consent. This is generic to all areas. So legal policy, which is really about D. So it's called fault-based liability. So only those at fault should be convicted and vice versa. The presumption of innocence is important for legal policy, that everybody's presumed to be innocent unless the evidence beyond all reasonable doubt proves that not to be the case. For legal policy, the actus reus must be vol. D must have chosen to voluntarily do that act. Prosecution must prove beyond all reasonable doubt that D had the mens rea and therefore committed the crime, otherwise D should not be guilty. The actus reus and mens rea should be occurring at the very same time, so that when you, for example, steal, you have the mens rea at the same time. The defendant must retain his human rights, because that is something that everybody should have in any just system. And the more intoxicated the defendant becomes, under legal policy, the more likely it will succeed, because he's probably not formed, therefore the mens rea. In terms of public protection, public policy, the aim of this style of case or legal principle is to protect the public and innocent victims. Public policy sometimes is harsh because it tries to encourage good behaviour. Justice is achieved under public policy by convicting those responsible for intoxicated crime. The actus reus and mens rea may not be there at the same time, as long as you're protecting the public. The victim's rights are the most important issue with anything PP based, and the greater the intoxication, the more likely D will be guilty under a public policy approach. So, how has intoxication evolved over the last 30 years? Well, the courts, so this is the Court of Appeal and House of Lords, have failed to reach a good balance between LP and PP. So, for example, self-defence and intoxicated mistakes is automatic no defence at all. That's far too harsh and should be taken into account for certain crimes, which means that's too much in the favour of public policy. Okay, so ultimately the courts consider that society needs to be protected by intoxicated defendants, and therefore the defence can only succeed in a small number of cases, sometimes at the expense of D's human rights. Now, basic and specific. So this is the next section. As I've said a few times there, what you have are two sets of rules, one for basic, one for specific. So for certain crimes there is one type of test, and for other crimes there is an alternative test. So how have the courts defined basic and specific crime? The answer there on the bullet points is there are lots of different rules and they all bring a different result, or some of them bring out a different result, which there should only be one test and we should have an accurate list of what is basic and what is specific, but we haven't. So what is the historical origin of the basic-specific distinction? How it all began is almost accidental. In one of the bigger cases on intoxication, so in the case of Beard, which was 1920, the judge in that case, Lord Birkenhead, talked in general terms, not meaning a specific test, but talked about situations whereby D intended or had a specific intent in mind, meaning a particular result. Lord Birkenhead never once referred to basic. He was just using the word specific as an everyday word rather than a specific test. So for example, what he was saying is if I go out and I intend to commit theft in a supermarket, then I'm going out with a specific intent to go and do that crime. So he refers to specific intent, but just in an everyday sense. Yet what the judges did afterwards is misinterpret that and believe that what Bid had done is create a specific test. But of course basic wasn't even mentioned, so the judge never intended to create this list. But that's what happened and evolved afterwards. So the most straightforward way to distinguish basic and specific is to adopt the intent and recklessness approach. I know I've just said there for an essay there are lots of different tests and they're all different, but if we don't go with one of the tests, then you'll never be able to apply intoxication. So this is the one that I studied when I studied law, and this is the one that we're going to use. But below I'll just explain the differences in the different tests, and that's more for an essay. Okay, so using the intent/recklessness approach, which is the one we're going to use for Section B or Section C, specific intent crimes are anything where the mens rea is intent. So if the crime requires intent, that is called a specific crime. If, however, the mens rea is recklessness, it could be intent and recklessness, but as long as recklessness is part of the mens rea, then that would be classed under this rule, a basic intent crime. So now what I want you to do is just write down the list of crimes in each section. Okay, so first of all, specific intent. So this is any crime with intent as the mens rea, as follows: murder, Section 18 GBH or wounding, TRB, theft, robbery, burglary, and attempts. So in the exam for a Section B or Section C, we will consider those to be specific intent crimes. For basic intent crimes, under this ruling, so this is anything where the mens rea is recklessness, the list is as follows: assault, battery, Section 47, Section 20 GBH or wounding, criminal damage, manslaughter, and rape. So those are the crimes we will consider to be basic intent for Section B and Section C. Now you'll see, but this is more AO2, which I'll give you on the AO2 sheet, that even though they're considered less serious crimes, certainly manslaughter and rape are clearly in the wrong list. There's no way in the world that manslaughter or rape should be considered as minor or less serious crimes. But this is one of the problems with each of the tests. Each test indicates that certain crimes are specific or basic when it should be the opposite. So we've just got to go with that. It's not right, it's not justice, but that's what those rules suggest. Okay, so for an essay then, you just need to tell the examiner a little bit about some of the other tests. So, various approaches. First one we've just used above, the recklessness approach. Intent is the mens rea for any specific crime and recklessness for basic. Now the second test, which another judge came in another case, so these have all come from different cases, the purposive approach. Now these get a little bit complicated, but I'll quickly run through these when we get back after the break. So the purposive approach, in short, this is where the crime involves the MR extending beyond the actus reus. So I'll give you some examples in a second to explain that. But generally speaking, we know the AR and the MR occur at the same time and are for the same event. Yeah? Okay, so we'll stick with that for now, and then I'll give you an example with assault and a second assault crime in a second. So the actus reus is A, but the mens rea is beyond that. So under this rule, the crime will be classed as specific if the mens rea includes the purpose of D's act, which goes beyond the actus reus. Some identifying result must be desired by D, which stretches beyond the actus reus. So this came out of Majewski and also mentioned in Heard, two different cases, and was first created by Lord Simon. So to give you an example of how that would work, with assault, we know the actus reus is the IPV. So D must do an act which brings about the apprehension of IPV. The mens rea is exactly that. D must intend or have SR for the IPV. So the mens rea does not stretch beyond, so that would be a basic crime. Okay, however, assault with intent to resist arrest, this time this would be a specific crime. The AR and the MR must equal out, as we've just seen with assault. Assault is IPV, the mens rea is IPV. Yet this time, you must have the assault, the IPV, plus the mens rea for that, but also the second further element of mens rea, which is also intent to resist arrest. So this means D's purpose is intent, goes beyond the actus reus. So that would therefore be a specific crime. Okay, so the next rule is called the fallback argument, which again has been used by other judges. This theory or rule suggests that specific crimes are those which have a fallback offence. So if it's a crime that can be reduced down, for example, 18 to section 20, murder can go down to manslaughter. If that is the case, then they would be considered specific. If a crime does not have a fallback offence, then that would be considered basic. So an example there would be theft. Theft, which we've just said above, we believe is specific. Theft would be basic under this rule. Theft has no drop down or lesser offence, so it can never be reduced down to a lesser crime. So therefore theft would switch, and under this rule would be a basic crime. Then lastly, the ulterior intent test. This is very similar to the purposive approach. Again, the mens rea under this rule goes beyond the actus reus, but the mens rea doesn't have to be an aim or purpose or intent. So although the mens rea stretches ahead, ahead of the actus reus, it could be intent or recklessness for an extra thing, whereas with the purposive rule, it's got to be intent. But it's basically the same. It's very, very similar. So this came out of Majewski as well, and this was Lord Elwyn Jones who created this. Okay, so some examples of how crimes would work under this rule. Theft would be specific, although basic in the one above we've just gone through. Yep, so theft will be specific because the mens rea goes beyond appropriation. We know that D must have intent to deprive and also be dishonest, so they go beyond intending the appropriation in question. And murder, the actus reus and mens rea equal out. The mens rea does not stretch beyond, so murder would be a basic crime. So clearly that would be wrong, that murder would be considered a less serious crime. Okay, so just wrapping up this section here. What problems have arisen with the basic specific definition, also called by the judges as the basic specific dichotomy. So that's quite a fancy word, but it's one that has been used by the courts quite a lot in relation to this difference or dichotomy of definitions. So dichotomy is dichotomy, dichotomy. Okay, so what problems have arisen? Too many tests and they are different. Another example of the difference, for example, criminal damage with intent or whilst being reckless as to endangering life. Under the recklessness rule that we're going to use, that would be a basic crime because recklessness is part of the mens rea. But under the ulterior or purpose test, purposive approach or test, the actus reus is the criminal damage, but the mens rea goes beyond that. D must have intent or whilst being reckless as to endangering life. So because the mens rea extends beyond, it would be a specific intent crime under those two rules. So it's very inconsistent and it depends which test the judge uses, which is very important for D. D needs to know whether he's going to be charged and treated under the basic rules or the specific rules. So D, again, must have some human rights. Okay, so what is the current test today? The answer is there is no current test. There's no one single test that is in use. Or that what the judges do is select which test they want to use. So that's not great and it's not consistent. But like I said, for us, we will go through the recklessness ruling when deciding for section B's and C's. Right, okay, so types of intoxication. So this is the next few sections of Intox. We have vol intoxication, which I call the Majewski rules, so that's next. Then two other categories or types of intoxication: intoxicated intent and Dutch courage. Invol intoxication beyond D's control, drugs from a doctor, soporific drugs and laced drinks or spiking cases. And then the final section is intox and other defences, how they combine together, which they often do. So voluntary intoxication, also known as the Majewski rules. This is because the key case is the case of Majewski. So voluntary intoxication, this is where D decided voluntarily to take the drink or drugs or both. So this is where the defendant has brought about his own intoxication, so therefore he has prior fault and on grounds of public policy will usually not receive a defence. It will always fail where the crime is basic, since that type of intoxication is considered a type of recklessness. Where you go out and choose to get drunk, that is an act of recklessness in its own right. Or taking drugs, that's an act of recklessness. So where you're charged with something where the mens rea is recklessness, you've already got that just in terms of getting drunk. For specific crimes, intoxication might be a defence if it prevented the defendant from forming intent. Ultimately, D's intoxication must be extreme. in order to remove D's ability to see a risk and prevent him from forming the MR. So he's got to be really, really, really high level, high degree of intoxicated. Right, so basic, just to make it clear, basic, no defence. You chose to get drunk or take drugs and you commit a basic crime, no defence. Specific, if D lacks intent, then the charge can be reduced. So section 18 to section 20, murder to manslaughter, etc. So just to go through the rules, we need to look at the different cases. So basic intent crimes, we've just said above, self-induced intoxication can never provide a defence. So the first case which decided this was the case of Majewski. The test of Majewski has since been refined, but the impact of Majewski still stands. So, in Majewski, DPP v Majewski, the defendant embarked upon a drinking marathon, whereby he took loads of different drugs and a significant amount of alcohol. So this was a drinking session that went over a couple of days, plus all of the drugs. He was asked to leave a pub, but tried to regain access, resulting in a brawl whereby D attacked several people, including police officers, the landlord and a customer. So D was charged with various counts of actual bodily harm and also assaulting an officer in the execution of his duty. Majewski claimed it completely blanked out and raised intoxication as a defence. D was convicted, however, and intoxication failed. D had shouted, "You pigs, I'll kill you all." This indicated he knew he was assaulting someone, and clearly he knew that they were officers. So, irrespective, regardless of any defence, he's got the mens rea. Remember, the basic rule is that intoxication will only succeed where D has no mens rea. And clearly, by saying those words, he had some mens rea. He knew they were officers and he knew that it was committing an assault. So, intoxication was always going to fail. In other words, what that is called, and it's a different section, that's called intoxicated intent. If you intended something whilst you were intoxicated, then you have intent. Even if you wouldn't do it if you were sober, intoxicated intent is still intent. Okay, so just a bit of judicial reasoning. So the trial judge instructed the jury should ignore the effect of the drink and the drugs. Intoxication can only be defence for specific crime. The House of Lords upheld the conviction and said yes, no defence. So this is the gist of the decision. Lord Elwyn Jones said that the act of self-induced intoxication can never provide a defence for any basic crime where recklessness is the mens rea. Why? Because taking drink and drugs is a reckless course of conduct. That's the important bit to highlight. That's the famous sort of bit of the legal principle of Majewski. That taking drink or drugs is reckless and a reckless course of conduct in its own right. And recklessness is sufficient for the MR for assault. If a man by his own choosing or volition takes a substance which causes him to cast off the restraints of reason and conscience, he should be guilty. So really, just paraphrase it at the side, getting drunk was reckless and therefore it automatically had the mens rea, which was a crime of recklessness. Intoxicated intent, the House of Lords decided this case, and of course the 7 judgments, because there were 7 judges, which often happens, or doesn't really today but used to. There were 7 different judgments which stated different things, so it wasn't clear as to which test they were using to divide basic and specific crime. However, there was wide support for the ulterior intent test, where the mens rea extends beyond the intent to do the act. So really, when you look at the different judgments, it wasn't clear, and the judges did go for different tests, which is a problem, especially since this was House of Lords. But really, there's a lot of detail there. However, all we need to know from Majewski is drinking is a reckless course of conduct, so it's automatic mens rea for the crime of recklessness. However, even though the impact of that is correct, what do people do when they go out on a Saturday night, Friday night, taking drugs, getting drunk? When they commit crimes, it tends to be criminal damage, fights, scuffles. So we don't want to give anybody a defence. It would be really bad, terrible public policy. If you choose to get drunk and you have a fight, well, that's your choosing. You should be culpable and dealt and charged appropriately. Same with things like criminal damage. However, the test that has just been set there is technically imperfect. Why? So, question, how does the decision of Majewski compromise Section 8 of the Criminal Justice Act 1968? So, as follows, the jury under the Act, Section 8, must examine every piece of evidence before they convict. And that includes D at the time and his foresight and the intoxication. The House of Lords held that all of the evidence quoted in Section 8 did not include intoxication. So really, what we're doing in Majewski is we're ignoring the intoxication, which isn't right, but also we're ignoring D's foresight, which that is not right. So actually, technically, it compromises Section 8 and it goes against the Criminal Justice Act, which is not good. So even though Majewski is a good test, the way it's worded doesn't quite work. However, the Court of Appeal changed the wording to suit Section 8, and that's in the next case. But overall, don't get me wrong, Majewski is a great case. Basic crimes should never be defended. It's the test that's wrong. It's worded imperfectly. So the next case is Richardson and Irwin. This was the case which altered the wording of the test in order for it to satisfy the Section 8 Criminal Justice Act. Okay, so Richardson and Irwin, there were several defendants who were university students who'd been drinking and engaging in horseplay when they dropped their friend, the victim, off a balcony. The defendants were charged with Section 20, having caused serious injury, but raised intoxication. Okay, so the prosecution argued the defendants had foreseen a risk and continued with that risk. The jury were instructed to consider each of the defendants' foresight using an objective test. So therefore the defendants appealed to the Court of Appeal, where the convictions were quashed. Court of Appeal held a misdirection had occurred. The jury should be told, in any case of intoxication, to consider D's foresight had he been sober. So if sober, the defendants, would they have the mens rea for the offence in question? So i.e., if sober, would these several students have foreseen a risk that dropping the victim off a balcony would result in some harm, but they subjectively nevertheless took that risk? Of course, if the jury were asked that question, intoxication would have failed. If sober, you would realise throwing somebody off a balcony that there is certainly a risk of some harm. Lord Clark, which I put this in for judicial reasoning because it quite amuses me, Lord Clark pointed out that these defendants were not hypothetical reasonable men, but merely university students. So saying there, basically, that a reasonable man test can't be used because these are not reasonable men. They are students. Oh. Okay. But how does this affect? How does it differ from Majewski? It doesn't really. It's the same result. Intoxication will still or should still fail for any basic crime, because when you take away the drink, D will always foresee things differently, will judge the situation differently. So it should still fail, but what you are looking is at D's foresight. So it satisfies Section 8. So intoxication is still no defence for any basic crime, but the courts have softened the wording of the test, looking at D's MR and therefore complying with the Criminal Justice Act. The courts will not presume that being drunk is auto-MR, but must assume D was sober and assess what he would have foreseen if sober. Intoxication will still 99% fail. And in short, I think it's right. If you think about it, let's just say I'm in my house and I drink a bottle of whiskey. That is clearly very reckless. But before I even leave the house, how is that mens rea? Recklessness for criminal damage, mens rea for manslaughter, mens rea for section 47. It's too simplistic to say you've been reckless generally in getting drunk, therefore you are reckless as to manslaughter, reckless as to criminal damage, etc. So I like Majewski, the test is just wrong. But now that's been sorted, and Richardson and Irwin is the test we should apply on section B and section C questions. Right, the next section is specific intent crime. So this is where D has committed a more serious crime and recklessness does not form part of the mens rea. So whether or not this succeeds will depend on the degree of the intoxication as to whether the defence will be successful. We don't want to give a defence to people who are just a little bit drunk, because clearly if they're a little bit drunk, they probably still have the mens rea. So intoxication will only be a defence, successful defence, if the court is of the opinion that the defendant was so drunk he wasn't able to form the necessary mens rea intention, in which case they can drop the charge to a lesser charge. However, the bottom line is if D had intoxicated intent, it's still intent. So if you intended it whilst drunk, you might never do it when you're sober, it doesn't matter. Intoxicated intent is intent. So there is an AO2 problem here with the issue of theft, which we said was specific. The problem with theft is that there's no lesser charge. So if intoxication is successful, then D will be acquitted, which is clearly not good public policy. If you commit theft and you're really, really drunk, you'll walk free from court. That's clearly not public policy, or good public policy. Right, so again you've got various cases which have tried to set the test for specific, and each time it's changed, and today the law is Sheehan and Moore. So in a section B or section C, all that you do in the exam is pick out the relevant category. So if the section B problem question asks about vol, you'll only talk about vol, Majewski, Richardson and Irwin. If it is a invol or a specific offence, then you'll just look at those cases. So you just pick out the relevant section. Okay, so these are specific cases. So Beard was one of the earlier cases in 1920. The defendant raped and killed a young girl, aged 13, called Ivy Wood. D placed his hand over her mouth in order to stop her screaming, whilst pressing his thumb over her throat, and she was suffocated and she died. D raised intoxication as he was too intoxicated to form the mens rea for murder, but D was convicted. In the trial court, D was convicted and appealed, stating that he was too drunk to form the MR for murder. Court of Appeal reduced the conviction to manslaughter, but then the House of Lords, in an unusual move, reinstated the murder conviction and D was guilty. So just to summarise there, the House of Lords did not give a successful defence of intoxication. So really what is important, and I think that's right, it's clear on the facts, he must have had the mens rea. And it looks very much like a case of intoxicated intent. So you don't want to give somebody who deliberately kills the defence. However, this case, the House of Lords set one of the earlier tests for specific, and the test was not a good one. But this is because Parliament have never intervened. So, Lord Birkenhead created the test. So I'll give you it verbatim in its detail, but then I'll explain and paraphrase at the side what in fact the test meant. So Lord Birkenhead said, where a specific intent is an essential element in the crime or offence, evidence of a state of drunkenness rendering the accused incapable of forming such an intent should be taken into consideration in order to determine whether he had in fact formed the intent necessary to constitute the particular crime. Right, that's very wordy. Let's paraphrase it at the side. What we had here is a test, which I call a capability test. So whether or not intoxication could succeed depended on whether D was capable of forming the MR. So I would just paraphrase at the side. Whether or not the defence could succeed depends on whether D was capable of forming the MR for the crime. So it sounds okay, but actually it's a very bad test. So question, what is the problem with this test? The capability issue is irrelevant. If you think about it, out of all the students at Notre Dame, so 2,000 students, how many, and teachers, how many are capable of forming the MR for theft? All of them. How many out of the 2,000 students and the teachers, a couple of hundred teachers, are capable of forming the MR for murder? All of us. Every single person is capable. But does that mean at the time of the offence it was intended or foreseen? So for example, I've given you an example before, a fight, or maybe if you were a victim of a burglary and somebody's coming up the stairs, a burglar, and you push them down the stairs. Every single person is capable of forming the mens rea for an assault or even worse, murder. But actually at the time, does it mean that we had the intent? Capability, yes, we're all capable. What the question should be really is examining whether at the time of the offence did D intend or foresee the crime. So it should be, did the defendant foresee the end result? Not was he capable, because we're all capable of committing any crime. So capability is irrelevant, and really the test was not technically accurate. So in the judgment, Lord Birkenhead referred to a specific intent, but just as an everyday word, but that led to the introduction of this basic specific dichotomy, and that was followed and picked up in later cases. Totally accidental. If you look at the judgment, Lord Birkenhead never ever intended to set a test, and he never ever mentioned the word basic. However, that's what happened. So in short, Beard, the capability test. In Lippmann, next case, D and his girlfriend took a drug called LSD and fell asleep at her flat. Now, one of the side effects of taking this particular drug is that often people who take it will suffer from really vivid hallucinations, whereby they see all sorts of different things that possibly do not exist. So it's a very dangerous drug. And D suffered a very bad trip, he argued and explained, and hallucinated that he was at the centre, the core of the earth, and was surrounded by attacking snakes, which he had to defend to save his own life. However, when he awoke, and his girlfriend, the victim, had been attacked, and a sheet had been crammed into her mouth. So he'd pushed this duvet sheet into her mouth. He raised intoxication for the charge of murder, but was found guilty of constructive manslaughter. So basically, during this trip, he couldn't remember anything that had happened. This is what he said in court. And he presumed during his hallucination that his girlfriend was one of the snakes. So the prosecution acknowledged that there was insufficient evidence for murder. That's unusual because the prosecution are paid to convict. So the prosecution acknowledged that there was not enough evidence for a conviction for murder, so they employed a conviction for the fallback charge, the lesser offence of manslaughter. The Court of Appeal, when this went on appeal, upheld the conviction for manslaughter. It was held that a person deliberately takes alcohol or drugs in order to escape from reality, to go on a trip. They cannot plead that self-induced disability is a defence to a criminal offence of basic intent. So, again, it's all a bit wordy, so let's deconstruct that. So what the court was saying is, yes, he did not have the intent for murder, which is what he was initially charged for. So because he lacked intent due to the intoxication, then they could reduce it to the lower down, lesser charge, which was manslaughter, which is basic. So, however, we know from the previous section, once you commit a basic crime, it's automatic no defence. So what this defendant was doing is said, yes, I've got a defence to murder because I lack intent, but I also want a defence against manslaughter. What the Court of Appeal said is no, once it drops down to the basic intent lower offence, you're back under the Majewski rules. And under Majewski, Richardson and Irwin, that it's no defence at all. So therefore it failed. Now, AO2, I do have a problem with this case. There is some illogical reasoning applied to this case. When you read the judgment, what they said in the court is because of this extreme hallucination, that the defendant was described as having no mind at all. So in other words, no mens rea. So how, if he's got no mens rea and no mind, how can that not be a defence for manslaughter, but it is for murder? Doesn't make sense. The court are acknowledging he had no mens rea, he had no mind at all, then he should be not guilty. I get it, we don't want to acquit him, he's still culpable, but it's the logic of the test. If he's got no mind or mens rea, then he's got no mens rea at all. But it is what it is. Yeah, it shows that even where it is a defence for specific, where it drops down to basic, it's automatic no defence. Okay, so, however, the next case is the one that's used today. So this is the test that should be used today. Sheehan and Moore. So the defendants were really drunk when they poured petrol over a tramp and set fire to him. The defence of intoxication succeeded as the defendants were too drunk to form intent to kill or intent for GBH. They were found guilty of manslaughter, so it dropped down to the lower offence, which is a basic intent crime. However, the Court of Appeal reconfigured the test, and this is the one you need to use, Section B, Section C. So, Court of Appeal confirmed that the question was not about D's capability, so it's not whether D was capable of forming the MR, but the question is simply this. Did D, at the time, with everything that occurred as it did, with the intoxication, at the time, did D form the mens rea for murder? Simple question. So, which is a good test? You're looking at D's foresight at the time, even with the intoxication, which you have to do, bearing in mind it's such a serious offence, and often the result is a life sentence, certainly for murder. So this demonstrates the use of the fallback principle, so murder became manslaughter. Court of Appeal held the question for the jury now on should be whether D formed the mens rea and not whether D was capable, even. And again, this case talks about intoxicated intent and confirmed that intoxicated intent is still intent. So keep coming back to that. A lot of the cases fail because of that last bullet. D intended his actions at the time. He might be the most mild-mannered person or woman in the world, would never have a fight, but if at the time, due to drink or drugs, he did intend the event, then that is intoxicated intent. So that's the strict public policy bit. But it is good because a lot of crimes are committed, as we know, due to intoxication. Now, the next section we've just touched on, but it is a section in its own right. So even though intoxicated intent is probably one of the main reasons why intoxication overall fails, we need to explain it on its own. So D might be trying to prove vol intoxication, basic specific, but it often fails for this section. So intoxicated intent, just write a little note there. This is where D's actions are deliberate at the time. D will always be guilty. If what he did was deliberate at the time, he will be guilty. So the case that we use for intoxicated intent is Heard. So, in the case of Heard, this was a defendant, very strange case. This was a defendant who was really drunk and was found in an emotional, drunken state, having cut himself. So he was taken to hospital, where they soon realised he was very drunk, but as he had become abusive, they removed him from the hospital. So the defendant began to dance provocatively in front of the police officer and rubbed parts of his body up and down a police officer's thigh. At the police station, he made the drunken remark, so this is where he's still drunk: "The only way I can make money is by moving my hips in a sexual way in Soho, and I thought I would get away with doing that to you, but obviously I didn't." So that's him drunk at the time saying to the officer, "This is what I do, this is what I did, and I thought I would not be, obviously taken to the police station." The following day, during the interview, when he sobered up, the defendant claimed he had no recollection at all of the events, but explained that when drunk he often became excitable and stripped. So he was charged with a sexual offence, a very serious offence against a police officer. Now clearly two things indicate that he had intoxicated intent. First of all, at the time whilst drunk he's saying, "Yes, this is what I do to make money, and I thought that I would not be convicted." And then the following morning he is saying, "Yes, I do that when I'm drunk, but I don't really want to do that when I'm sober." But both of those two bits of evidence are indicating that he had intoxicated intent. Okay, so the jury convicted, he was guilty. Court of Appeal upheld the conviction because the crime that he'd been charged with, sexual assault, is basic intent. So really, intoxicated intent is academic. If it's basic, it's no defence under Majewski. But the second reason why it failed, he did have intoxicated intent, which is still intent in law. D will have no defence whatever is committed. If he did it at the time deliberate, he's got the mens rea. The fact that D was very sorry afterwards and would never have done it if sober is irrelevant to the verdict. And that's right. That's public policy again. Okay, Dutch courage, intoxicated intent. So this is another type of intoxicated intent, which is where D plans a crime, has the mens rea for a crime, but then also deliberately gets drunk to give him the confidence, the courage to go and then do the crime. So D still has intoxicated intent, and clearly D has the mens rea before he even does the crime. So it's pretty obvious that this will never be a defence. Okay, so the case this time is the case of Attorney General and Gallagher. So in this case, the defendant planned to kill his wife, who'd been involved in getting him sectioned into a mental institute. So obviously he wasn't happy with that, and he planned and formulated a plan to kill her, which involved buying a knife, and then he went and bought some whiskey, which he then deliberately drank the whiskey to give him the courage to commit the murder that he'd planned. Lord Denning said that intoxication could not be a defence, as the defendant had already formed the mens rea before the intoxication even took place. So in other words, he had the mens rea for murder before he even got drunk. So clearly that can never be a defence. The trial judge convicted the defendant as the jury passed a guilty verdict. House of Lords said yes, Dutch courage is no defence, which is great PP. Right, the next section is involuntary intoxication. Now, just write a note at the side. The general rule is where invol is successful, it will acquit all crimes. And really, rather than trying to think about the specific rule, just think about generally the levels of culpability. If you are voluntarily drunk, clearly that should never really be a defence, or very rarely be a defence, because you chose to get drunk. You took the drink or the drugs and chose to get into that state. But where it's invol, that is beyond your control. Your culpability is much, much, much lower. And therefore, where it does succeed, it doesn't always, because it's still very public policy based, but doesn't always succeed. But where it does, it should acquit the defendant, because we are accepting that it was not his fault. Okay, so there are various sections and categories of involved intoxication. You've got drugs from a doctor, prescribed drugs. You've got soporific drugs, which are a particular type of drug, which I'll explain when we get to that category. And then there's the spiking cases, which the judges call that laced drinks. So, for doctors who give drugs to people who then have an unusual reaction, this section applies. So, prescribed drugs. So, where the defendant takes a drug from a doctor, but then it has an unusual effect and he becomes intoxicated as a result, he may have a defence to all crimes, basic and specific. This will only apply where D takes the drug and is completely unaware of the reaction that it would have. So if this happens, if D takes a drug and he does have a funny reaction to the drug and then he takes it again, that will be no defence. So effectively it's got to be the first time that he's taken this drug. Okay, so an illustration of that is the case of Bailey, John Bailey, in 1983. This was also an automatism case, but as we'll see in a little while, both defences normally come together. If you're really, really drunk, you're also in an automatic state. So often defendants plead more than one defence, in effect, which is what I'm saying. So D was a diabetic, and he'd been a diabetic for many, many years, over 30 years. And so he'd taken his insulin, as diabetics do, had some water and a little bit of sugar, but forgot to eat. And this triggered something called a hypoglycemic seizure and a loss of consciousness, during which he attacked a man. The man, coincidentally, being his ex-girlfriend's new partner. And he'd done this with an iron bar. So he was charged with Section 18 and Section 20, GBH, and was convicted. Now, we will get into diabetes on the insanity topic and automatism topic, so I'm not going to go into too much detail now, but basically diabetics have to manage their own levels of insulin. So automatically it normally works for people who don't have that condition, but where you are diabetic, you have to artificially monitor your insulin. So after 30 years, after a couple of years, you know exactly what you need to take and how to regulate your condition. So the trial judge directed the jury that as the state of mind and his condition was self-induced, that intoxication and automatism both had to fail. Now, Court of Appeal said that was a misdirection. They agreed that the jury be misdirected, but the conviction was deemed safe. So sometimes where there is a misdirection, they still find the defendant guilty. The misdirection you might want to add on there is actually what the judge had said was incorrect. Where it is self-induced, you can have a defence for Section 18 because that's specific. But he was right for Section 20, that's automatic no defence for a basic crime. However, the judge, the Court of Appeal, felt that had the jury been correctly instructed, they still would have convicted. Various reasons why. When they looked at the medical evidence, although a loss of consciousness was possible from his condition, it was not possible in such a short time after he'd taken the sugar and the water. In other words, yes, he could have had a hypoglycemic seizure, but not straight after having the sugar and the water. That would have come at a later stage. So in other words, they are questioning whether or not really he did have a seizure. The second reason why the defence failed is Bailey chose to go and visit this man, the victim, and also armed himself with an iron bar beforehand with intent to attack the victim. So he already had intent, he'd gone round, he'd planned it, so at the time he had intoxicated intent. So for two reasons the defence failed: intoxicated intent, but also in terms of the drugs from the doctor, really what we're saying is he was considered under voluntary intoxication. It wasn't invol. If he'd taken the insulin that first time or first few occasions, then it could be a defence. Prescribed drugs would be a defence. But after you've been taking the drug 30 years, he knew exactly what would happen if it did happen, and therefore he was considered and switched back under the Majewski rules. So in other words, he was trying to establish invol, because that would be an acquittal. The court rejected that. It was vol, and therefore no defence for section 20. In any event, he had intoxicated intent. So it's just this illustrates how drugs from a doctor work. Okay, second category of invol intoxication is called soporific drugs. So soporific drugs or calming drugs such as sedatives and tranquilizers are drugs which do not have an inhibition, lowering or mind expanding effect. Instead, they generally make a person sleepy or relaxed. The defendant will be entitled to a full acquittal, full defence, as long as he wasn't reckless in taking the drug, i.e. foresaw the likely outcome of taking the substance. So let me just elaborate a little bit more. These are drugs. Often doctors give these to people who have anxiety issues or nervous flyers, for example. They'll give them sedatives. Where a doctor gives, let's say, 100 people, or probably even like 1 million people, if you gave 1 million people a tranquilizer, you might get 1 in 1 million that has this funny effect. The rest are just chilled out, relaxed, but 1 in 1 million will have an unpredictable reaction and will often turn excitable, violent, and unpredictable. If that is the defendant and it's the first time it ever occurred, then he can have a full acquittal. If he's already taken it once and takes it again, that will be no defence, because that will be classed as vol intoxication. So the case that rules this particular point of law is Hardy, 1985. So in this case, the defendant was depressed and upset since his relationship with his girlfriend had ended and he was being asked to leave the flat they had shared. So he was really stressed and anxious and upset. So his girlfriend said to him, she convinced him, take some of my Valium. She'd been prescribed the Valium and it was there for whatever reason, but she knew it would calm him down and chill and make him relaxed. So he did exactly that. He took some of the Valium. However, Dee then set fire to a wardrobe while she was out, and he was charged with criminal damage, being reckless as to whether life would be endangered. So the trial judge said that Dee had voluntarily taken the drug, so therefore, because it was basic intent, no defence. Court of Appeal disagreed, and they quashed the conviction. This was not vol, it was invol. Court of Appeal created a new category of invol, which was soporific drugs. So this was major news, this case, creating a new category of invol. And said that this type of intoxication, invol, could include soporific drugs and can be a full defence for any crime, basic or specific. So the test that was set, was Dee reckless in taking the Valium, i.e. did the defendant realise or foresee the likely outcome from taking that drug? And the answer to that is no. He could not have predicted in 1 million years that he would have that reaction, and therefore that was classed as invol. So it was a full acquittal as a result. If Mr. Hardy then did it the week after, that would fail, that'd be classed as vol. But because this was unpredictable, therefore it was classed as invol, full acquittal. A second soporific drugs case is the case of McGee, which is more recent, 2013. This was a defendant who suffered from like an ear condition, severe tinnitus, and had been prescribed a tranquilizer, which is a soporific drug, to help him sleep. The defendant had been instructed to avoid alcohol whilst taking the particular medicine. However, one night at 4 a.m, after drinking lots of alcohol, he went to an off licence to buy more alcohol and stabbed the assistant with a knife, but he couldn't remember anything after the event. So the trial judge held that this was a case of vol intoxication and not invol. Remember, vol is where you choose to drink, invol is where it's beyond your control. As above, in Hardy, we said that was the first time he'd taken the drug. It was unexpected, therefore that was invol. But this time the judge is saying it's vol because he knows the likely outcome, plus also he's chosen to drink. The Court of Appeal rejected Dee's appeal. Dee was fully aware of the dangers of mixing alcohol with the soporific medication, hence this could not be classed as invol, but voluntary instead. Dee was convicted of Section 18 with intent, as he had also had intoxicated intent in any event. He deliberately went round armed with a knife, and if you remember from the last couple of sections, whatever happens in any case involving Intox, if Dee intended his actions at the time, that's it, game over. The defence will never succeed, irrespective of whatever other conditions apply. So, because he went armed, he had intoxicated intent anyway, so the defence would always fail for this defendant. Okay. So, what are the problems, AO2, with soporific drugs? Well, actually, there's a few issues. First of all, it's not easy to distinguish what drugs are classed as dangerous and those which are not. What the judges have done is sort of categorised in certain cases dangerous drugs such as cocaine, heroin, and then soporific drugs which are sort of classed as a separate type of drug. But there's no clear list. And of course, the judges are not medical people, so they've just sort of done it ad hoc, case by case. So the question arises, what is a soporific drug? For example, heroin is an opiate, hence should that be classed the same as Valium, which is a soporific drug? I can't see any judge ever saying that heroin is a soporific drug, but actually it is related to Valium. So it's not very clear medically which ones would fit within this category. The line between drugs which sedate and those which promote aggression is not clear cut. And also what happens when soporific drugs are mixed with alcohol. So there's lots and lots of questions, and it's another one of the aspects of the defence where we would say Parliament therefore need to reform. Now the next case, and next section, is spiking cases, which the judges tend to use the phrase laced drinks. So this is where the defendant is completely unaware that they are consuming an intoxicant, as his drink has been laced, or her drink has been laced. He or she may have a complete, full acquittal, full defence. However, the defendant must lack the mens rea, because remember that's the bottom line. If you've got intoxicated intent, or if you've got intent, intoxication will never succeed. So that has to still apply. And the courts have been really strict on this section as well. And I think I tend to agree with that, because if spiking cases were very generously applied, lots of people, this would be their first line of defence. Why did you commit that theft? Why did you commit criminal damage? Why did you have that fight whilst you were drunk? Oh, I was spiked. That would be such a popular defence, so the courts have had to be strict on it. And that's public policy, of course. The second reason which you need to add onto the handout, the second reason why intoxication and spiked drinks is harsh and rare to see as a successful defence is that Dee has to be drinking a non-alcoholic drink. Now, normally in genuine spiking cases, the victim may have had one or two drinks, or maybe just one, and then they are spiked into that one drink, but it will fail automatically because you have to be drinking a non-alcoholic drink, so no alcohol at all. So everything is designed on this section to fail in the name of public policy. Right, so the case where this was discussed, such a controversial case, and it's one of those cases I never really quite decide whether it's rightly or wrongly decided, but it's one that does gather a lot of discussion. So this is the case of Kingston, and this was a defendant who had openly admitted he had homosexual and paedophilic tendencies or desires, but he had managed to keep the paedophilic tendencies under control forever while sober. However, the defendant, Mr. Kingston, was being blackmailed by a former work colleague. So Kingston and a young boy were both enticed under false pretences to a flat where their coffees were spiked. So both the defendant and this young lad had been spiked with a strong drug. Yep. Then the individual who was blackmailing Kingston encouraged and goaded the defendant into sexually assaulting the boy, which he did, and the blackmailer recorded this all on film, and then he intended to use the film to extort money out of Kingston. So not very nice character at all. Dee argued that he would not have committed the act ever if sober, since he was always able to keep his desire under control. Dee was intoxicated but not unconscious, but Dee was charged with quite clearly a serious sexual offence. So what this defendant is saying is, yes, I did do the act in question, but I never ever would have done it in a million years had I not been spiked. And with the evidence from the video, it was 100% agreed he was definitely spiked and then blackmailed. So the trial judge directed the jury that if Dee was so drugged that he did not intend the crime, then he should be acquitted. The prosecution, however, argued that despite the effect of the drugs, there was evidence that he intended to commit the act at the time. And of course, as we've said a few times, that's evidence of intoxicated intent. Court of Appeal quashed the conviction and held that if drugs are surreptitiously given to a defendant, then he is not guilty if he formed an intent which he would not have formed if sober. Invol intoxication could apply even where Dee had the MR but would not have done it without the invol intoxication. Just note at the side of that section what the Court of Appeal is saying there. It was not Dee's fault. So they were taking sort of a moral view that they accepted that this defendant had been blackmailed, had been bribed, had been drugged, and therefore he would never have done this if sober. House of Lords, however, took a completely different approach. The House of Lords held that intoxicated intent is still intent in law. Dee had to be guilty even though the intox was invol. So the House of Lords took a very, very strict approach. But again, I think it's public policy on two grounds. Number one, preventing abuse of the defence, because people would try to abuse the section of spiking and use the defence unnecessarily. And number two, also grounds of public policy. This case involved paedophilia, which of course is something very serious that has to be prevented in society. Okay, so the next case indicates what is not spiking or laced drinks. In the case of Alan, this is a defendant who is saying he knows he's drinking an alcoholic drink, but he doesn't know or isn't aware of the strength of the intoxicant in question. So what the courts have said is that where you know you're drinking, but you're just not aware of how strong it is, that is not spiking, that is not a laced drink scenario. But again, it's voluntary intoxication, so back under Majewski. So in Alan, Dee consumed some homemade wine, which was extremely strong in alcoholic content. The wine had an unexpected effect on Dee, and he claimed that he was so drunk he had no idea of what he'd done. Dee became heavily intoxicated and committed a serious sexual assault. Dee claimed that he had not voluntarily put himself into that state of intoxication because, yes, he knew it was wine, but he didn't know it was really that strong. Intoxication failed since this was not classed as invol, this was not classed as spiking, but back under Majewski. It was voluntary intoxication. As Dee knew he was drinking, the strength was irrelevant. So the Court of Appeal convicted Dee of the sexual assault in question, and what he'd done is commit a basic intent crime, so under Majewski there was no defence available to him. Right, the next section then. The next section is, or the last bit of the handout actually, is intoxication and how it works when combined with other general defences, or specific defences. So really this section, thinking about potential examination questions in the exam. For an essay, everything we've done so far, which is vol, invol, basic, specific, on the handout, that's the main body of the essay. Then all you would need is a small section on intoxication and other defences. Really, this section onwards more sort of relates to your section B's and section C's. So just to recap there, you would need a little bit of this in your essay if you were tackling an essay on intoxication, but most of this, and there's quite a bit of detail, is required for your section B's and your section C's. And in fact, some of this we've done before, so there's intoxication and mistake, we've already done that. It's just cut and paste from that self-defence handout. Also DR and intoxication, which we've done. So this is just bringing together the combined effects of intoxication and other defences. Okay, so we'll start out with insanity, which is the last topic we need to do. Insanity, so this is where the defendant has prolonged and persistent intoxication, so he's drunk or taken drugs or both for many, many years, which leads to then a disease of the mind. The defendant will be placed under the McNaughton rules. Right, the McNaughton rules are the rules which govern insanity. So this is a defendant who's drunk so much over so many years, they actually get a disease of the mind. So they've got two live defences that they could possibly put before the court. You've got insanity and intoxication. But what that first line is saying, insanity and intoxication equals one thing, insanity. So intoxication becomes irrelevant. Insanity is the only defence available. So you might just want to write that beside to make it clear. Insanity plus intox equals insanity. That's the only relevant defence. So a case to illustrate this section, Coley. So this was quite a recent case. D was a regular user of cannabis and one evening watched a violent video game, having taken the drug, and then experienced a brief psychotic episode. He visited his neighbours and attacked them with a knife but couldn't remember anything afterwards. When the police were called, D was shouting for his mother and threatening suicide. The Court of Appeal upheld the conviction as the relevant defence was indeed vol, intoxication, and D possessed the MR for attempted murder. Insanity and automatism could not be applied. The trigger of the episode was an external cause, not internal, which is what insanity deals with. Furthermore, the automatic state was caused by self-induced intoxication, so automatism also could not apply. So in other words, the cause of his psychotic episode was external, it was drink, drugs even, and therefore the relevant defence was the voluntary intoxication rules. So Majewski applied rather than insanity or automatism. So case to contrast that is the case of Harris, which was also 2013. And to put there a note, Coley, McGee and Harris, McGee's earlier on the handout, were all jointly appealed. So separate cases, separate facts, but if they go to the Court of Appeal or House of Lords on the same legal principle, we've seen this before, they go on a joint indictment, joint appeal. So in Harris, D developed a habit of drinking excessively during his time off work. So if I remember from the case, he sort of had continental shifts where he worked 5 days on, 5 days off, something like that, or 3 days on, 3 days off. But he had long periods off and then he'd work for several days. So he got into the habit of when he was off work, drinking excessively and then not drinking at all when he was working. So this triggered an episode of alcohol psychosis, during which he heard voices instructing him to set fire to his house. and he did exactly that. D was charged with arson, aggravated criminal damage, after pouring petrol in his house and setting it alight. So on the surface it looks very similar to Coley. However, this was differently decided. The Court of Appeal allowed the appeal as his condition was caused by past vault intoxication, which had then triggered a mental disorder. D was not intoxicated at the time, therefore this could be dealt with under insanity rather than intoxication. So how do these cases differ or compare? Because on the surface they look very similar, so it's important to distinguish the two different rulings. So in Coley, so this is the one with the cocaine, and he attacked his neighbours. At the time of the offence, he was taking drugs, so Intox was the relevant defence. Harris, he was not drinking at the time. It was afterwards. Hence, this was not intoxication. So, what we're saying there is D has to be taking the drink or the drugs at the time of the offence or just before for it to be a live consideration as defence. So one was Intox, one wasn't. Very similar culpability. Yeah, when we look at the two defendants, that actually both, the bottom line is both of their conditions were caused by either taking drink or drugs, yet one was intoxication and one wasn't. So it does seem that both defendants have got very similar culpability, and there's not a massive difference on the facts, but yet one is intox and one isn't. So again, this is a section whereby I would suggest Parliament need to reform, because that distinction there is not very clear. It comes down to timing, which I don't think really is the crucial issue. Right, automatism. So this is intoxication and automatism. This is a very common combination. Automatism, which is, again, the penultimate topic, or the last set of two topics. Automatism is where, due to a reason, you are placed in an automatic state and your body acts and your muscles act in a way that has no control over the mind. Well, when you are in an automatic state, yeah, that can be a defence. But also when you're drunk, that often leads to a defendant being in an automatic state. So there's quite a lot of defendants will try to raise automatism instead of intoxication, because it's a more generous defence. So anyway, automatism then, where the defendant has become very, very drunk by drink or dangerous drugs and he acts in an automatic state, it's intoxication that applies. So in other words, just to summarise at the side, intoxication and automatism equals intox. So automatism can't be put forward before the court. So again, that's public policy. The courts are only allowing the stricter defence to be considered. So the case here is a case of Lippman, which we've just looked at right at the beginning of the handout. Lippman, that was the defendant who took the LSD and strangled his girlfriend, thinking he was at the core of the earth, surrounded by snakes. And self-induced intoxication, of course, succeeded, and it brought murder down to manslaughter. D further argued that he was in an automatic state, hence he tried to raise automatism. However, it was held that this was a case of intox and not automatism, since it was a drug well renowned to have a dangerous and unpredictable effect. Therefore, the only defence available was intoxication. So, what happens? Question mark. What happens where D takes or ingests a drug not known to have a dangerous effect? So these are some of the new drugs that I just see on TV, a lot of new drugs that are coming out that people take, that are given street names. So I think that's an example of that. If somebody takes a drug for the first time and it's never known to have a dangerous effect because nobody really knows about that drug, that can be a full defence. and that will be classed as invol intoxication. It also could be classed as invol automatism. And it can be a full defence to both basic and specific as long as D is not reckless. So this little question here is just about the new drugs, or if new drugs evolve, then the courts would tend to say, like with soporific drugs, that it can be a full defence if D wasn't expecting any reaction at all. Okay, intoxicated mistakes is the next section. And a lot of this we did on the self-defence handout, so we can run through this really quickly. There's just one new case, which is the case of Fotheringham. So we know this ruling, we said it on self-defence, intoxicated mistakes will never provide a defence to any crime at all, basic or specific. And we said that was really harsh. And the Law Commission have looked at this several times and said, yes, it's wrong, it needs to be reviewed, in that where it's a specific crime, it should be taken into account. Doesn't have to be successful, but just take it into account as with normal vol intox. However, intoxicated mistakes, we know the rule is game over. It's never a defence. So, Fotheringham. So, this was a case. It wasn't a self-defence case, but it is intoxicated mistakes case. So, in Fotheringham, it was the babysitter who was 15, who was looking after a young child, and the parents, so Mr. Fotheringham and his wife, gone out drinking, and then come home. Then Mr. Fotheringham went upstairs and raped his wife. In fact, he had made a mistake. It was the 15-year-old babysitter. So that's the defendants argue. He didn't deny that he'd raped, and this is before 1991, so it's before RVR, which you might have done in precedent. So he admitted that he forced his wife to have sexual intercourse, but of course it wasn't the wife, so he pleaded mistake, that he mistakenly believed it was his wife, that he'd forced to have sexual intercourse. So we know that, just forget the issue of mistake for now. Rape is classed as a basic intent crime, which is a big AO2 point. How can it be basic? But that's what the courts have said, so we have to go with that. So rape is a basic intent crime, and under Majewski that's automatically no defence. So whatever this D argues, he will never have a defence of intoxication. Then, of course, adding the second issue, his mistake, intoxicated mistakes never succeed. So in other words, this D is guilty of rape, and rightly so, for two reasons. Basic intent crime, and that will always fail, but also intoxicated mistakes will never provide a defence. So D was guilty, and that's clearly justice. Right, O'Grady and Hatton are mistakes involved with intoxication, but also self-defence. So we know these cases because we've done these on the self-defence handout. So O'Grady was the one where they'd been drinking. D and his friend had been drinking lots of cider, and then both fell asleep. And then D explained he woke to find his friend hitting him, mistakenly thought he was being attacked, so he picked up the ashtray, hit the friend, and the friend was found dead in the morning. The important bit here, as we said before, is that he was charged with manslaughter. Manslaughter is basic, so mentioning or arguing a mistake is completely irrelevant. Basic intent crimes, under Majewski, no defence. So intoxication failed as the crime was basic and D was reckless in getting intoxicated. So that's fine, and we know intoxicated mistakes never succeed. So it's rightly decided the defence failed, but it was the obiter that was made by Lord Chief Justice Lord Lane. So Lord Lane went that a bit further, obiter, and said intoxicated mistakes should not ever apply to specific crimes. But that is a problem because it's inconsistent with the normal law of Intox, where self-induced can be considered for specific crimes and succeeded in Lippmann and Sheehan. In other words, if D had not made a mistake, the defence could succeed and would be considered, but yet the defendant, if he's made a mistake, is less culpable than Lippman and Sheehan. So in other words, it makes no sense. Intoxicated mistakes should be considered at least for specific crimes. So, why is Lord Lane's view heavily criticised? It's just too harsh. Do you commit a specific crime whilst drunk? So, for example, going to a pub, getting drunk and killing somebody, it can be successful and reduced to manslaughter. However, do you commit a specific crime under a mistaken belief of self-defence will automatically have no defence. The example I gave you there is if somebody having a bottle of wine or some beers and then mistakenly believing there's an intruder who then gets thrown down the stairs and injured and either Section 18 or murder, that would be automatically a life sentence if that was murder. So it seems inconsistent and unnecessarily harsh. It should be allowed to be considered. It doesn't have to succeed, but at least let them consider it for specific crimes. Okay, and the case which picked up that obiter, made it into law, was the case of Hatton, which we saw again on the self-defence handout. So the defendant drank 20 pints of beer, so he was extremely intoxicated and attacked, killed a man that he'd invited back from the pub to his flat. The defendant claimed he couldn't really remember what had happened. He seemed to remember the victim was dressed in combat. He seemed to remember that he had a 5-foot stick, or it could have been a knife, he wasn't sure. And he seemed to remember he thought he had to make use of self-defence as this guy was potentially assaulting him stroke killing him. So it's all very blurry. So his allegation is self-defence via mistake, obviously with the drink. Court of Appeal held that intoxicated mistake could not provide a defence now to basic and specific crimes. So the defendant was convicted of murder as a result. So this time, O'Grady was, of course, manslaughter, which is basic. So this was the first specific intoxicating mistakes case. So the Court of Appeal picked up the obiter, made that into binding precedent, and now this is the case that ruined it, basically, that now intoxicating mistakes will never provide a defence to any crime. Which is unfortunate, really. You don't have to give this defendant the defence. In doing so, in creating this ruling, what they could have done is left the obiter and still refused to accept it, in that D may have well had intoxicated intent, for example. It doesn't have to succeed, but you can give it consideration. But this case has outlawed that. It's gone. Intoxicated mistakes and no defence at all. And then, strangely enough, the codified Section 76 Act, which codified self-defence and prevention of crime, confirmed that this was good law, which I find quite surprising, but there you go. So how does that compare with Majewski, the Hatton ruling? It's inconsistent with Lippman and Sheehan. Under the normal rules of voluntary intoxication and Majewski, basic, no defence. Specific can be, not always, but can be a defence and reduce the charge. Whereas this is saying basic and specific, automatic, no defence. So that is definitely inconsistent and definitely something that needs to be looked at. And then we've got another issue, is that there is one exception to intoxicated mistakes whereby the intoxication can provide a defence. So we've just said above, intoxicated mistakes never succeed, and then there is one exception, criminal damage, which again is anomalous and is an AO2 critical point. The exception is under the Criminal Damage Act 1971. So just to note there, within the Act, there are a couple of defences that are cited within the Criminal Damage Act. One, which is where D has an honest belief the owner would have consented to the damage, then that defendant will not be guilty. So even if the defendant is drunk, if he or she has an honest belief that the owner would have consented in the circumstances, then D will have a defence and he will not be guilty of criminal damage. So what we're saying there is intoxicated mistakes are no defence apart from criminal damage, which is basic, so that should never be a defence. So it's another problem with intoxication. And the case which brought about the anomaly was the next case, Jaggard and Dickinson. So Dee had permission from a friend to treat her house as her own. So it was two friends, and the other friend had said, yeah, whenever you need to use my house, do so. One night, whilst drunk, having no key, she'd lost the key, she thought, I'll break into the window in order to get into my friend's house, thinking in the morning she'd obviously pay for the window to be repaired. So she broke into a friend's house to get inside, and in fact what had happened is the taxi driver had dropped her at a different house which looked identical to the property she was trying to get into. So she raised self-induced intoxication for criminal damage, even though that is a basic intent crime which always fails under Majewski. So really this had all the hallmarks of this is no defence, it's criminal damage, which is basic, which is no defence, plus it's an intoxicated mistake, no defence. However, on appeal, the defence succeeded under the Criminal Damage Act since Dee had an honest belief, a drunken belief, but an honest belief that the owner would have consented to the damage. So her friend wouldn't have minded her doing that. So intoxication succeeded. So why is this criticised? The result of this case criticised. It completely goes against everything under Majewski. Basic intent crime, no defence. And Dee, in this case, was reckless in getting so drunk that she didn't even recognise the house. So intoxication should never be a defence. But it's also inconsistent with all other areas of intox. So intoxicating mistakes as well. Right, so, and the last section, last defence, is diminished responsibility. Again, we've done this bit, so we can fly through this. So intoxication is often paired up with DR. So where DR is depressed, for example, or schizophrenic, or got any sort of abnormality of mental functioning, and they kill, often this is combined with the fact that they were drinking or taking drugs. So intoxication may impact upon a plea of DR in a number of ways. So we have the three sections on the DR handout: intoxication alone, intoxication and pre-existing disorder, and intoxication and addiction, stroke, disease. So intoxication alone, that's an easy one to eradicate. Intoxication alone is no defence. Where you go out and get drunk or take drugs or both, yes, internally you won't be thinking or acting in the same way. However, the courts have rightly said that this is not diminished responsibility, it's just intoxication. So that defendant is going right back under the Majewski rules. Just being drunk is not diminished responsibility, it's not an abnormality of mental functioning. So the example of that which was on the DR handout was the case of Dowds, which involved the girlfriend and boyfriend, both binge drinkers, got extremely intoxicated, and D attacked V, 60 stab wounds later, tried to raise acute intoxication under the defence of DR. And of course the Court of Appeal said no, getting drunk, which is called medically acute intoxication, is just intoxication, it's not diminished responsibility, which is right, it's good PP. Intoxication and separate disorder. So this is where D has a condition such as depression and then just happened to be drunk on the night that he or she killed. So we know the case of Deachman, we know that very famous case where his auntie, who was also his girlfriend, had died, and he'd been at the party and then a fight erupted whereby he kicked and punched a man to death who'd accidentally broken his watch. So the House of Lords held the following 3 bullet points, which is exactly the 3 on the DR handout, that intoxication could be considered. So the question was, without the alcohol, did D have an abnormality which would prove DR? So remember we talked about test 1, test 2, so it's that test 1 that we call test 1. on the handout. So without that alcohol, did D have the abnormality which could prove DR? Secondly, the abnormality did not have to be the sole reason. Both the drink and DR could play a role. So that's the bit where we said, wow, that's generous. So it could be 60% is depression, 40% the drink, but that was accepted by the court. It was incorrect to say that the test was without the drink would D have killed. So, i.e. not test 2 on the DR handout. So, in other words, intoxication can be part of DR on those type of facts. It doesn't have to be the sole reason, as long as without the alcohol or drug, did D have the AMF, which could prove DR. Finally then, we've got intoxication and addiction. Again, we've done these, so quickly moving through them. Tandy was illustration that addiction to drink or drugs were never taken seriously by the courts and never accepted as part of DR. So Tandy was the alcoholic who killed her daughter, and she tried to raise diminished responsibility, DR, because she had clearly a medical issue, which is alcoholism. However, of course, DR failed because of the test, which was a ridiculous test, which is a 2-part test, which could never be successful. Number 1, the drinking or the drugs, but drinking on these facts, had to be involuntary, 24/7. And also there had to be evidence of brain damage. And of course, with most alcoholics and drug addicts, that cannot be established. So DR failed as a result, even though she had a genuine addiction. Then the law changed, of course, in Wood. That was two alcohol-dependent people, the defendant being one of them, spent a day drinking, and then he killed his friend with the meat cleaver. Court of Appeal reviewed their opinion on alcoholism and drug addiction and softened the law in light of Deachman. And this is where ADS, or alcohol dependence, was now part of DR, or potentially part of DR. ADS was now a disease that could be an AMF. Brain damage is not required. And the jury must then decide whether the ADS substantially impaired D's mental ability. So in other words, ADS now can be an abnormality of mental functioning and can lead to a successful plea of DR because it is a medical, genuine condition. Finally then, procedure. D is required to adduce evidence of the intoxication, so sort of raise it and prove some evidence of intoxication before the defence can be a live issue. Whether the intoxication was sufficient is a question of law for the judge to decide, so he has to decide whether or not he's going to allow it into court. If there is not enough evidence to suggest that D lacked MR, the judge can withdraw the defence. D is not entitled to an automatic acquittal. If he fails to form the MR, he is entitled to have the evidence considered only by the jury. Again, that represents the harsh public policy approach that intoxication should not be a regular defence.